to everyone, both in person and those of you who are online, to this seminar on money, politics, and the First Amendment. My name is Barry Burden. I'm a professor of political science here at UW-Madison and director of the Elections Research Center. This event is co-sponsored by the Elections Research Center and the State Democracy Research Initiative, which is co-led by Professors Miriam Seifter and Rob Yablon. So thank you to both of them. Thank you also to the Wisconsin law firm Stafford Rosenbaum LLP for sponsoring this series of Election Matters events. If this kind of event is of interest to you, I encourage you to online, ERC or our website. Follow our social media accounts. Those are the best ways to find out about upcoming events of this kind. To get us started, I want to introduce David Hollander, who's going to be introducing our speakers. David is a partner at Stafford Rosenbaum. He's involved in multiple areas of practice in both state and federal courts, but most importantly, he is chair of the firm's election and political law team. David.
Thank you. Thanks. It's a real pleasure to be here and introduce our speakers here. I'll start at the far end with Professor Wood, work my way back towards me. Abby Wood is a professor of law, political science, and public policy at the University of Southern California Law School. She serves as a commissioner on the California Fair Practices Commission and the Commission's Digital Transparency Task Force, and served on the Federal Bipartisan Campaign Finance Task Force from 2015 to 2017. Her research on efforts to improve public governance via information provision has been published in many peer-reviewed journals and law reviews. Abby earned her BA from Austin College, her JD from Harvard Law School, an MA in Law and Diplomacy from the Fletcher School at Tufts, and a PhD in Political Science at the University of California, Berkeley. Our next panelist is Ray La Raja. Ray La Raja is a professor of political science at the University of Massachusetts Amherst and is co-director of the UMass Amherst poll. He has written and co-authored 2 books on campaign finance, and he received the Virginia Gray Best Book Award from the American Political Science Association for his 2015 book, Campaign Finance and Political Polarization, When Purists Prevail. He also co-founded and served as the former editor of The Forum, the Journal of Applied Research and Contemporary Policies. Ray has served as an expert witness in federal court cases on campaign finance, including the U.S. Supreme Court case of McConnell versus FEC. He earned his master's in public policy from the Kennedy School of Government at Harvard and his PhD at the University of California, Berkeley. Our next panelist is Benjamin Ginsberg. Ben Ginsberg is the Volcker Distinguished Visiting Fellow at the Hoover Institution. He's a nationally known political law advocate and compliance expert with 38 years of experience representing participants in the political process. His clients have included political parties, political campaigns, members of Congress and state legislatures, PACs, governors, vendors, and donors. He has represented 4 of the last 6 Republican presidential nominees. He served as co-chair of the Bipartisan Presidential Commission on Election Administration from 2013 to 2014. He was a partner at Jones Day from 2014 to 2020, and at Patton Boggs for 23 years before that. He's also currently a CNN contributor and often appears on the air as a political commentator. Ben earned his law degree from Georgetown University Law Center. And last but not least, Saurav Ghosh. Saurav is the director of federal campaign finance reform at the Campaign Legal Center, where he works to pursue legislative and regulatory reforms to ensure enforcement of federal campaign finance laws. Before taking that position in 2022, he served for almost 7 years as an enforcement attorney at the Federal Election Commission Office of General Counsel. He also previously served as Special Assistant U.S. Attorney in the U.S. Attorney's Office for the District of Columbia. Saurav received his law degree from Stanford Law School, where he was awarded the Carl Mason Franklin Prize in International Law. He earned his undergraduate degree from the University of Pennsylvania. So please join me in welcoming all of our panel.
All right, so with this terrific lineup of speakers, I want to tell you about the format we're going to follow today. Each speaker is going to take 10 minutes to present their comments, And then we'll follow that with a Q&A that I will moderate. So we want your questions, whether you're in the room attending in person or online. If you're here in person, you'll see index cards on the desks. Those are opportunities to write down questions. They will be picked up by volunteers, bringing them up to me. So write those down, then send them forward anytime during the presentations. If you're online watching on Zoom, please use the Q&A function to submit your questions, not the chat. The Q&A function will be watching that and work both the online and in-person questions into the conversation. Keep in mind that the event is being recorded, so you may be seen on camera. Things you say may be recorded as well. For those of you who are here in person, there will be a reception afterwards just outside, so please stay around if your questions didn't get asked and bug our panelists once they're out after the event. This event has also been approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners. If you're attending in person, there's a sign-up sheet near the door of the room. So if you have not done so already and would like credit, please sign that sheet before you leave today. If you're attending virtually and would like CLE credit, please listen for the passcode that I will give just after 4 o'clock. You will enter that passcode into the Google form that's being provided in the chat box around the same time. Complete that form by 5 p.m. Central Time for your credit. So a couple thoughts about the topic we're going to be covering today, this intersection of free speech rights and campaign finance regulation. I'm not the expert that these 4 panelists are, but my view from the margins is that the playing field has tilted pretty decisively in favor of the free speech side of that tension and away from greater regulation or public provision of campaign finance. Why does it seem like that has happened? One, I think, is the ineffectiveness of the Federal Election Commission as the enforcer and the regulator of those things at the federal level. The FEC has mostly lacked a quorum of commissioners to do business, including just now because one of the Republican commissioners just left the commission days ago. It's also often lacked the staff and resources to do the kind of work that you might expect. When it is fully staffed, there's often deadlock between the Democratic and Republican commissioners who are equal in number. The IRS might also be an enforcement agency because so much money is now funneling through 501c organizations regulated through the tax code. The IRS seems unprepared to regulate dark money. It's beyond its scope and sometimes has been pushed back for moving into that area. Another factor are court decisions from the federal courts, from the US Supreme Court in particular, that have moved away from an early focus on corruption as a concern, as a state interest to prevent, to think about corruption in much narrower terms. It may only be about a donor giving money to a politician in the hopes of getting some personal benefit from that transaction, a kind of bribery, maybe as a statutory crime. But Citizens United and a whole range of other decisions we may know less about have really opened the doors to different kinds of spending that don't seem to violate that narrow definition of corruption, as long as the spending is independent and uncoordinated with the candidate or campaign, it's viewed as not crossing that line. I think the internet and technology have also been part of the story. Soliciting money is now easier than ever, happens across state lines and across district lines in a way it did not used to. And there's advertising done digitally that I think was not well anticipated by statutes that were written at the time that most advertising was happening on television. And then finally, there's been a tremendous creativity on the part of people who have money or want to get money to use on campaigns. Their inventiveness has no end. We have joint fundraising committees between parties and PACs and candidates. We have the passing of funds between 501c groups and super PACs and campaigns. We have candidates who begin to run for office without declaring their campaigns so that they can use 527 accounts to support them. We have groups providing free B-roll footage to campaigns or the other way around so that they might be used as kind of a handoff that's not coordinated. Even surreptitious communication via social media posts to send signals between groups that are not coordinating with the campaign and the campaign. Here in Wisconsin, we saw Elon Musk get involved in the Supreme Court race this spring, doing things that I had not imagined before, like paying voters to take selfies or awarding million-dollar checks to people who enter into lotteries. So the creativity is maybe part of the American way of doing things, but it has really opened the doors to ways for money to be influenced, I think, that were never anticipated and not well governed at the moment. So we're going to turn to our speakers in a different order than they were introduced. We're going to start with Saurav Ghosh.
All right. Thank you very much. And It's really a privilege to be here and to talk about these important issues with you. So thank you, Professor Burden and SDRI, for having me today. I want to talk about some of the work that I do at Campaign Legal Center and really focus on some of the current challenges in the campaign finance landscape. Professor Burden touched on a few of these, and I think probably the best way to frame what I see as the biggest challenges is to start with Citizens United and some of the baseline assumptions underlying that decision, how they've played out over the past 14 years, and how they actually played out in the 2024 election. So the categories I'm going to focus on are transparency, independence, and the lack of real or apparent corruption. So the court in Citizens United approved the spending of corporate money on elections, something that had not been allowed to that point. But they made two basic assumptions in approving that. One of which was that all of the spending would be openly disclosed, that it would be clear on the required FEC disclosure reports who was spending the money. And the second assumption was that all of that spending would be independent. It had to be legally separate from candidates' campaigns as well as political party committees. What we have seen over the past several election cycles since Citizens United is that neither of those assumptions has ever really been true. So I'll start with the disclosure piece of it. Dark money is and continues to be one of the biggest problems of our campaign finance system, of our elections generally. The idea that folks can look at disclosure reports to glean who is actually spending money on elections is really just a theoretical concept, because it's never been easier for special interests, corporations, the very wealthy, to spend money on elections without really any kind of disclosure that they are in fact doing so. In the 2024 election, dark money groups, nonprofits, these 501c4 nonprofit corporations, as well as shell companies, spent more than $1.9 billion, which is a dramatic increase over the previous record for a presidential. It was $1 billion in 2020. So if you look at a number like $1 billion or $1.9 billion, and that seems like a number really hard to conceptualize, it's a remarkably large amount for us to have no idea where that money actually came from. And that, I think, really illustrates the extent to which the Supreme Court's assumption that all of this spending would be openly disclosed has proven to be utterly fictional. Is there a solution to that kind of problem? One bill that has been in Congress for many, many years is called the Disclose Act. And what it would essentially do is require groups that spend money on elections above threshold amount would have to disclose where that money came from. And unfortunately, Congress hasn't really shown any initiative in passing that. But a state has actually taken the first steps towards showing how that system could work. In Arizona, the people, essentially through the initiative process, passed something called Prop 211, which it works a little differently than the Federal Disclose Act, but it accomplishes essentially the same goal, which is to trace back spending on elections, whether it's through a corporation or through a shell. All of the money has to be traced back to the original source, providing a way for the public to have actually real transparency about where money is coming from that's being used to influence elections. So on the disclosure piece, I also want to talk a little bit about the FEC. The FEC, as Professor Burden mentioned, is often a wholly ineffective regulator. They're the agency that is responsible for enforcing and implementing campaign finance laws. So in the disclosure sphere, I think one of the biggest things they did in recent days was finally, after many, many years of delay, requiring disclaimers, which are those messages that say who paid for an ad, on digital ads. These are the ads that you see on social media and on the internet. But less in the good news side is that they actually explicitly carved out political promotion by influencers. And this is actually a fast-growing sphere of political influence, paying individuals who have, well, I don't know if I need to explain what an influencer is. It's a pretty young crowd. Um, Paying influencers to either create content boosting a candidate or an issue, or to promote content that is given to them. At present, there's no disclaimer required on that kind of content. And I think that's one area where the FEC still has important work to do, because influencing is already garnering a tremendous amount of political ad spending. So I don't have a ton of time, but I want to talk quickly about the other piece of the Citizens United assumptions, and that is coordination or the independence requirement. The Supreme Court said that all of this outside spending has to remain independent. It can't be coordinated with political parties. It can't be coordinated with candidates' campaigns. But the reality of most of the time since then is that campaigns and political parties have found many ways to openly coordinate. Whether it's through red boxing, which is this practice in which they publish instructions for the kind of ads they want outside groups to run, and then signal to those outside groups that they should look for those instructions. Or other tactics like using vendors in common between campaigns and outside groups. These are tactics that the FEC has never taken a serious effort to curb. CLC put out a report in November 2023 with what I think is a shocking finding, that in all the years since Citizens United, the FEC has never once penalized any group or campaign for coordinating. So that either means that no one has coordinated in all that time, or it means that the FEC has wholly failed to enforce the law. And in 2024, somehow that situation was made even worse, because the FEC issued an advisory opinion requested by a Democratic group, actually, called the Texas Majority PAC, which in that opinion, the FEC explicitly stated that coordination was allowed for paid canvassing. In a very technical way of reasoning, they arrived at that conclusion. And I think this was the first time that election spending by an outside group was allowed to actually be coordinated explicitly. And lo and behold, groups were paying very close attention to that. And one of the groups that took the most clear advantage of this was Elon Musk's super PAC, the America PAC. Now, Elon Musk spent north of $250 million during the 2024 election, and a significant amount of that money was actually spent on these paid canvassing programs, where basically they hire workers to go door to door and urge them to vote for the candidate Musk wanted, Donald Trump. And I think the really shocking part of that is that all of that canvassing could be openly coordinated with Donald Trump's presidential campaign. So again, showing that, for the last however many years since Citizens United, the FEC was already not enforcing laws coordination. They somehow found a way of making things even worse in this last election, and we saw the almost immediate result of that, which is clear coordination between a special interest and a presidential candidate. So again, there are solutions to that. There are federal bills that would essentially redefine coordination so that it is meaningfully enforceable. The FEC's test for what is coordinated election spending simply isn't working, or at least their way of interpreting that test isn't working. And again, the bills that are in Congress, they were part of the Freedom to Vote Act, would redefine the concept in a much more common sense way. I will wrap things up by simply saying that I think the larger question about corruption, is, are candidates and elected officials, are they, subject to real or apparent corruption by genuinely independent, openly disclosed spending? The Supreme Court in Citizens United said, no, they're not. If, this spending is disclosed and independent, no risk of corruption. I think the challenge is, sitting here all these years later, we really can't say one way or the other, because we have never actually seen a system of campaign finance laws where all of that outside spending was disclosed and where it was genuinely independent. So I'll leave it there and look forward to hearing my other panelists' comments.
Thank you, Saurav. All right, let's go to the other end of the table to Abby Wood.
Always fun to hear a former FEC lawyer spill the tea, what goes on the inside. So I have been working in this area for quite a while, and in watching the kind of deregulatory march under First Amendment jurisprudence, I kept thinking, well, when they do this strict scrutiny analysis on these challenges to the campaign finance laws that exist, they're kind of assuming that the harm that the plaintiff alleges exists, and they give very little kind of real estate in the opinions to talking about the public harms that the ethics or campaign finance laws are meant to prevent, or or to ameliorate. And so I thought, well, why don't I try to measure that? And so this last time I taught my money in politics seminar, my students and I decided we were going to write a paper together. And this is very early results from a survey that we ran. So we met in January. We had to get through IRB approval and all this kind of process to get to where we could actually use human subjects. And then we raced and got a survey done. We're working on other pieces of it. And so these are the students that remain. The rest of them I lost to the bar exam and to law firms. But
Abby, can you just pull the mic closer to you?
on actually. Can you hear me now? I totally did that thing. He was like, there's always something who sits back and doesn't use their mic. My bad. So, in looking back through kind of the long time democratic theory type stuff, you see that even from a, really libertarian perspective on regulation, preventing public harm justifies the creation of laws. And that's true for murder statutes, and it's true for environmental laws, and it's true for these ethics laws, okay? And as I just mentioned, we get kind of an easy pass for individual harms that are alleged, and very more of a hand-wavy discussion of the prevent. So the language that you've already heard mentioned, right, was corruption, the appearance of corruption as a compelling governmental interest for upholding these laws, okay? So in thinking through how we were gonna write this survey, we thought, well, we should at least do a typology of the types of public harms that we think these laws exist to prevent. And we didn't want to give them to the people we were going to be surveying first. We just wanted to come up with it and then hold it and then use it at the end of the survey. So here's what we came up with. So if you have ethics violations, you might end up in a situation with a lot of government dysfunction and waste. The idea that very little gets done. Okay. Or maybe you end up with policy related harms, meaning the wrong things get done. The policies that the bribe givers or the donors want get through, but not what the public or the constituents would want. Maybe you end up with these informational or enforcement or accountability harms that could happen with, lack of disclosure or fraudulent disclosures and things like that, because a lot of our ethics regime is really just about transparency, okay? And then finally, we thought, okay, probably a harm would be this idea of political distrust and illegitimacy. And I will tell you, we were hoping to not see much of that because it's difficult. It's multi-causal. So the first three things on that list can cause or exacerbate public trust problems, okay? Political rhetoric against government can also cause that. Let's shrink the government. They're all corrupt. They're not working for us. That can also make you not trust. Also allegations, whoever they are, they're in power, they're corrupt, don't trust them. I wouldn't trust them with anything, right? That works against it too. And so when we see declines in trust, we don't really know what's causing them unless we kind of put people in a lab and give them, take a trust measure and then ask them a question, give them a prompt that has a ethics violation, and then take another trust measure would be a way to do it. That's not what we do here. We were just hoping to not see it. If trust dips, that can lead to other harms like non-compliance. So if you don't trust your government and your government is the one approving the vaccines, telling you to wear a mask, asking you to pay taxes, right? Then you may decide not to comply with the laws that are part of the government, okay? So we did a survey. I can tell you more about it later, but the basic idea is we're snowball sampling. We're trying to contact experts. We're getting in touch with people like I used to be, these commissioners on state level enforcement bodies for ethics and campaign finance. We're also trying to find the defense side of all of these. Who's the named lawyer who's helping the candidate who the state is going after. And so we worked through a bunch of websites to do that. We end up with 88 responses, and the average time was 12.5 minutes, which is an absolutely astounding amount of time to spend on a survey. I'm very grateful to these people. So I'm going to show you a few early results. So one thing we say is please rank the following ethics violations by the amount of harm they cause. This is the first question they see. They're given 7 randomly selected ethics violations from this larger list, okay? Consistent with other research, we see that bribery is considered the most harmful, okay? But we have campaign finance stuff showing up right away. Straw donor schemes, that's when you give in the name of another. Okay. The fourth one is lying on your campaign finance disclosures. We said false campaign finance disclosures. Campaign finance donations from an ineligible source. Okay. So in states that don't allow corporate contributions, for example, personal use of your campaign funds. So all of that comes quite early in ranking them from top to bottom. I will tell you in other work I've done, I had some kind of violations that I thought weren't as important, like missing deadlines that I was prompting the public with, and they were quite punitive on those, far more punitive than I thought they should be, frankly. And I was relieved to see that the experts thought, they're just deadlines, we're not going to stress about this. And so you can see the late lobbying disclosures, late campaign finance disclosures, and late public official financial disclosures are all considered a low degree of harm. So then we gave them, this is what took forever for them. We gave them open text boxes and asked them to write about these harms. Okay, so I'm going to just show you 3 examples, one from the high harm, one from the middle, and one from the lower one. So in a few words, please explain how the public is affected if a government official takes a bribe. And somebody says detrimental to the public trust and effective administration of democracy, right? So a trust harm, but maybe a dysfunction harm too. Okay, how about by personal use of campaign funds? This is stealing, plain and simple. If a public official will do this, what else will they do? So that's maybe a trust, maybe a legitimacy harm, okay? And then finally, late filing of lobbying disclosures, which as a group, they had all said was not very harmful. This is very insignificant as long as they have timely registered as lobbyists. Okay, so I was really excited to see their words. And so what we did after that was, and this is really early what I'm about to show you, but we did some text analysis, okay? I'm gonna break this down and it'll look less confusing, hopefully. But I found some words that would lead toward the idea of an information harm, that's the red, a policy harm, that's the blue, trust harm is green, and these waste harms are purple. I didn't find any enforcement language, okay? So now I'm just showing you just the campaign finance violations. So the substantive ones are here. I don't know if you guys can see, but on the left, everything's preceded with a D. Those are all the disclosure requirements that we thought about. And then on the right, they're preceded with an S. That's some more substantive stuff. So the substantive stuff, bribes, campaign finance limits, personal use. You're seeing language about trust and policy harms from the respondents. The disclosure violations, the thing they're most consistent about is informational harms. That's the red bars there, okay? Now, if we were to look at other substantive violations like conflicts of interest, gift limit violations, and nepotism, you're seeing, again, language about policy and trust harms, much less about information and waste. Okay. And then other transparency or disclosure violations, again, we're getting a lot of language about information, but a little stronger on the policy harms language as well. Okay, so I thought that was really interesting. Sometimes the court gets it right, you know? When the court writes about disclosure, they're writing about information harms. The ethics experts agree with that part. The piece that I think, well, I'll talk about it in a minute, but the piece I think the court may be kind of less concerned about, right, is this trust thing, unless you want to read appearance of corruption as a trust harm. So just very quickly, how severe are the following public harms that result from breaches of government ethics and campaign finance laws? So this is kind of our typology that we give to them. So there's a couple of these categories that they're answering that they haven't actually come up with on their own, okay? And as you can see on the left, so severe is orange, moderate is green, minimal is blue. They're actually really concerned about trust, and they're really concerned about legitimacy harms. Okay, so there's a lot more thinking to do here. So just to wrap up, right? So under the First Amendment framework, this would be analyzed under the government interest prong. Okay, so is preventing these harms like trust or information or policy, is that a compelling government interest, right? Or is it an important government interest, which sometimes is the language you see for exacting scrutiny? Maybe we have some conceptual slippage. Maybe we want the government to write laws explicitly aimed at increasing trust, or maybe we don't. And I think there's just a lot more thinking to do about that. But I just wanted to kind of give you guys some fresh research that I'm still working on and hear what you think. Thanks.
Thank you, Abby. Before we turn to the next two speakers, we're at the midway point. So I'll just remind you, if you'd like to submit a question, now's a great time to jot that down, either in the Q&A function on Zoom, if you're online, or on the index cards that are here. Just lift that card in the air and someone will come by, grab it from you and bring it to me so it can be asked. Next up is Ray La Raja.
Thank you to SRL and the other partners for hosting this event. So today I want to talk about two issues in campaign finance that I've been working on closely. The first involves a case now coming before the Supreme Court, the National Republican Senatorial Committee versus the FEC. I was an expert witness in the case at the trial stage. And so I want to give you a sense of what's at stake and why it matters for U.S. elections and institutions. Second topic is the rise of small donors in American politics, a subject I've studied with my co-author Zach Albert for a new book, and I'll be connecting the two issues at the end. So let me start with the NRSC case. The question in front of the court is whether political parties should continue face strict limits on how much they can coordinate directly with their candidates. And the plaintiffs argue that coordinated limits violate First Amendment by blocking the most basic form of political association between parties and their own candidates. They say corruption is already checked by donation caps. So the extra limit on party spending is a needless double profile. And under the McCutcheon decision, only quid pro quo corruption justifies such restrictions, something that transparent regulated parties are least likely to commit. So in other words, the plaintiffs in the NRSC case want the court to take a strict scrutiny approach in regulating political parties rather than a closely drawn approach. So
Ray, can I just check, make sure your mic is on? We got a little note that people are not hearing.
Okay. Where is the?
Should be a button on top there.
And the green shows it's on.
Right, may just be a matter of being close.
Okay, how's that? Okay, great. So my testimony spoke primarily, that sounds better, to the impact of restraints on political parties and democracy more broadly. You know, to most people outside of election law, it seems odd that party committees cannot simply pool resources with the nominee and run a campaign together. In most democracies, this is not even a question. Parties and candidates are inseparable. But in the United States, campaign finance laws force parties to behave like interest groups, separate operations if they want to advocate for their own candidates. So why should we care? Because, in my view, political parties are essential institutions in a mass democracy. They are vehicles for collective action. They recruit candidates, they build agendas, they mobilize voters, and when they win, they govern. And strong parties are accountable. And if they fail to deliver, voters can throw them out. But if parties are weak, this is what's happening right now. Systems fragment, other actors, super PACs, issue groups, armies of small donors fill the vacuum. And these groups are less accountable and more extreme. The danger is not simply inefficient campaigning, it's a government system that is prone to stalemate and polarization. So this brings me to the coordinated spending issue. So under federal law, the amount a party can spend in coordination with the candidate is capped by a formula, and it hasn't kept pace with modern campaigns at all. I'll give you a concrete example. In 2022, the National Republican Senatorial Committee spent about $2 million in coordinated expenditures to support J.D. Vance in the Ohio Senate race. They essentially maxed out, okay? But the striking part is even if they went up to the limit of the ceiling, these coordinated funds cover just 14% of total campaign spending for the candidate and the party in that election. Vance's campaign spent $12 million, and the opponent, Tim Ryan, spent $61 million. So think about that. Even in one of the most competitive Senate races of that cycle, even when the parties spent every dollar they were allowed, it played a relatively marginal role. And the rest of the money came through all these groups we know about, dark money, super PACs, from individual donors. And it's hobbling what I think is the one institution that's designed to integrate different factions. So I think the system has it backwards. You know, parties and candidates are natural allies. The laws are forcing them apart into fragments. And that's why this NSRC case is so important. It's not just the technical details of the spending caps or the First Amendment, which is obviously important, but we don't want parties to remain marginal players. So let me turn to the second subject. This is small donors. I just finished this book. Reformers and most Americans celebrate small donors as an antidote to big money. So the image is appealing. Ordinary citizens give 20, 50 to their favorite candidate, creating a more democratic form of financing. And indeed, we've seen them grow dramatically over the decade. Act Blue, Win Red, online platforms, they make it really easy with a few clicks. So the numbers are impressive. They provided billions of dollars in recent elections, sometimes rivaling what individual large donors give. But here's the rub. Small donors they're not representative of the broader electorate. The research that we've done shows they're disproportionately older, wealthier, whiter, and more educated than the average American. And more importantly, they are more partisan and more ideological. They don't give because they want to curry favor or get access, and that's a good thing. They give because they're passionate. Great, they're passionate. And that passion means usually supporting the most polarizing candidates, the candidates that are good at getting their name out there. Bernie Sanders obviously raises a lot of small money. So does Donald Trump. So does Marjorie Taylor Greene. So I don't want to say that, you know, it's all bad, of course. You know, they do bring energy to politics. They allow challengers. They support challengers more. And you're not relying on the big insiders for money. But the idea that small donors naturally leads to moderation or broad representation is misguided. If anything, the surge of small donors, in my view, makes our politics, or at least reinforces polarization. They're not the only reason. Reinforces polarization because they do give to the most fiery rhetoric and they like ideological purity. So what do these two issues, the NRSC case and the small donors, have in common? They both highlight this paradox at the heart of American campaign finance. The rules, they celebrate individualistic forms of financing from passionate small donors or from billionaires giving to super PACs. And at the same time, the rules, in my view, shackle the institutions that could bring some coherence and accountability into our system, the political parties. The result is, again, politics, I think, dominated by extremes. And I don't think, you know, the party should be left to the sidelines. I don't think there should be any restrictions. I'd be differing from Saurav here on money, on imposing any party support on their candidates at all. Parties should be permitted to help their candidates as much as they desire and in direct contributions or in-kind support. So if we care about strengthening democracy, I would take a different attitude than what most reformers typically want. I want to build institutions that are broadly accountable to broad constituencies. So we need to rethink campaign finance law, especially as it relates to parties, and I think that's what this case does. It doesn't mean silencing small donors or independent groups, but it does mean elevating the role of parties. Let me close with this thought. Both the NRSC case and the rise of small donors forces basic question. Do we want a democracy where fragmented voices and billionaires dominate, or where one political parties, or flawed though they are, help channel conflict and constructive collective action? And I think our system tilts too much towards the billionaires and the extreme small donors. So I think we need to reimagine how we deal with this and make sure we ensure diverse participation, which is the hallmark of American democracy. I'll stop there.
Thank you, Ray. And last, Ben Ginsberg.
Thank you. Thank you all very much for having me. Thanks for SRL for putting this on. It's great to talk about these issues, although certainly with the current cast of issues that we've got today, this one is taking sort of a different perspective than it might have had a dozen years ago. I want to give you the perspective that I have, which is a little bit different. I was a practitioner for 40 years. I worked in campaigns representing Republican Party committees and candidates. And what's interesting, I find that there is really only one eternal truth that both the pro-regulation side and the anti-regulation side agree on, and that is that the current system ain't working, that it's flawed. And so I want to talk a little bit about how that came to be. And I want to make the argument as an offshoot of what Ray said, is that really this is a system that was flawed from the very beginning. It has not worked for 50 years, and it's worth exploring the reasons why to figure out how you can create a statutory scheme that is better than everyone hating it. I don't think this all started with Citizens United by any stretch of the imagination. The original promise of the Federal Election Campaign Act back in 1974-75, and as amended by McCain-Feingold, was pretty simple. The goal was to squeeze the evil money, in other words, large corporate interests and special interests, out of politics by limiting the size and sources of contributions to candidates and their political parties, and by empowering small dollar donors and having full disclosure. Over the past 50 years, that has not happened at all at any point. The system today is completely upside down from that, which is what I think you've heard everybody saying in one form or another. Whatever that original intent was, things have disintegrated to the point where campaigns today are so dominated by special interest groups and their money that, and think about this, candidates and their political parties are not the loudest voices you hear in campaigns. That's backwards. Agendas, as well as the blocking and tackling of how campaigns are run, are now driven by large dollar groups and really the large money that the original 1974 law and the McCain-Feingold Amendment tried to stop. That's the very money that's dominating our politics today. So there's a lot to unpack about how campaigns are run and why this is a bad situation and how it came to be. And certainly the new, rather disruptive and evolving media environment plays a huge role in that. But it's certainly not everything. But a fair summary of how campaigns are run is that they depend on the 3 M's. They depend on money, they depend on messaging, and they depend on mobilization. Back in the old days, and I think in a functioning system, those would all be done primarily by the people who are actually running for office and their surrogates in the political parties. The political parties are, or should be, positive forces for the reasons Ray just mentioned. But today, the parties and the candidates are certainly not the dominant voices in our campaigns. The statute places limits and prohibitions on candidates and parties, but really not on special interest groups. So the basic functions of how campaigns operate now falls heavily on the very sources the original campaign finance laws and the amendments set out to stop and prevent. The reality of campaigns today, to drill down on that a little bit, is that a special interest group has a large treasury throughout an election cycle at the beginning and the end. So they have a great deal of power of setting the agenda. They can go to their people in Congress or the White House, get them to deal with the issues, not necessarily the issues that the candidates want to present to their voters, but candidates, because they raise their money in tranches later in the election cycle, don't always have the ability to impact the very issues that they're talking about. In terms of messaging, I mean, Ray gave you the figures, but the amount of money spent by entities other than candidates and political parties is far greater than what the people actually running for office can spend. And in terms of voter mobilization, get out the vote, the blocking and tackling of knocking on doors or motivating people through internet communications to go out and vote, think about it. Turning Point USA versus the Republican National Committee in 2024. It wasn't even close. The same thing was true on the Democratic side. In terms of disclosure, the disclosure scheme as it's set up, I think, has proven totally ineffective to get at whatever you were trying to do. It's really a question of too much information being out there with the vast amounts of disclosures so that you just don't see revelations that seem to shock voters at all. I appreciate Abby's study about voters and what motivates them. And I think if you ask people in sort of the tight box of those issues, they'll tell you that. But in any poll that looks at national issues that voters use to determine who they're going to vote for, it's not campaign finance. And it's none of these sorts of laws that really rises to the top of the heap. The coordination rules have really not worked out. It's certainly true that there is a way for candidates, parties, and outside groups to communicate. It's called public communications. They're not illegally coordinating, they're legally coordinating because there is a First Amendment, everyone can talk. Candidate puts up a statement on a website on his or her position on taxes, and a group that wants to do ads on taxes reads that and figures out how to do it. That's not illegal coordination, that's speech in a democracy. Ray described the sort of farce of the party committees not being able to talk to their candidates when they spend the money that they can spend. And that's just simply dysfunctional and really an unnatural act. And the internet and its advent has made it even easier to put up public statements that groups then react to. So I think if this admittedly malfunctioning current system is ever to work, it's important to admit that the basics of the Federal Election Campaign Act and the McCain-Feingold law are just flawed. They've never worked, and they will never work as long as there is a functioning, breathing First Amendment. I do appreciate that there are those who believe that the system would have worked if only the courts had enforced the laws the way the original drafters of that legislation meant it. The problem is there weren't many practitioners who are actually helping to draft the laws, so that there's a disconnect between what the law tries to do and what actually happens in the field, in the campaign field. And it's important to recognize that the Supreme Court has taken away chunks of the original law and its amendments consistently since the 1970s, long before the current court, long before the Citizens United court, whether it was Buckley or Bellotti in the 70s, Mass Citizens for Life in the 80s, Colorado Republican One, about party independent expenditures being okay. In the 90s, McConnell and Wisconsin Right to Life. In the first decade of this century, Citizens United, Arizona Free Enterprise, and McCutcheon. In the last decade, and even in this decade, the FEC versus Ted Cruz on candidate loan repayments. The point is that proponents of the law can point to really constitutional only on perhaps the Shrink, Missouri case that did allow low limits that candidates could raise. The Austin case on corporate IEs, which was then overturned 20 years later in Citizens United, and the Colorado Republican 2 case on upholding coordinated limits. That's the case Ray mentioned, NRSC versus the FEC, that's now before the Supreme Court. And I think we can all guess on how the court's going to come out on that case. So it's time to reimagine. It's rather than doubling down on what was a flawed contest. Ray mentioned some of the solutions that are possible. Hope we get some time, Barry, to talk about possible solutions to the morass. But I do sort of want to begin with the fact that you have to go back and not blame the courts and not blame the practitioners, and recognize that perhaps the basic concept of limiting what candidates and parties can do and having a First Amendment that puts roadblocks in the way of limiting what special interest groups can do is a flawed way to go about regulating this area.
Thank you, Ben. Let's thank all of our speakers for their comments. All right, terrific questions rolling in. We're going to start with regulation and enforcement. If there's agreement, the FEC is not the ideal design for regulating campaign finance at the federal level, what would you do to the FEC, or what would you replace it with? Are there any models at the state level of agencies that actually work effectively? Maybe Saurav is the person to start here.
Sure. So the FEC is wildly ineffective. I think that's something all of us can agree on. There are certain structural reforms that have been proposed. They've been in bills before Congress. We would have to have a functioning government for that to happen, but thinking long term, some of them are possible. One is to change the number of commissioners. So by design, the FEC has 6 commissioners, and they have always been essentially 3 Democrats and 3 Republicans. For many years, that structure worked just fine by consensus. But starting around 2008, the system stopped working. The 3 Republican commissioners began voting as a block and generally voting to block enforcement of the law. That led to a lengthy period of deadlock where on most substantive enforcement matters, the FEC simply could not garner the 4 votes needed to go forward. So there were a lot of 3-3 deadlocks. The law did not keep pace with campaign practices. As I mentioned in my opening comments, the coordination rules were never enforced. It was a big problem. Recently, in fact, it's gotten somewhat worse. And sorry, I'm elaborating a bit about how bad things are, but I'll get to why I'm doing that. Recently, the commission, when it had 6 commissioners, was voting 4-2 with one of the Democrats joining the 3 Republicans to deregulate, to strip down many of the important guardrails that had been there for years. The Texas Majority PAC advisory opinion that I mentioned, which explicitly permitted coordination between outside groups and political candidates, that was one of those 4-2 decisions. And so I think the problem really isn't just about the number of commissioners. Certainly changing that number might help to get past deadlocks. It's also who's serving on the commission. Right now, the way commissioners are selected, the president officially has to nominate them, but it's the majority leader and the minority leader in the Senate. They pick who they want. And, in some respects, maybe campaign finance regulation is always politicians trying to regulate themselves. So they pick folks who are going to favor their interests. But having a blue ribbon panel of experts to select really qualified folks who would actually enforce the law would, I think, improve who is actually serving on the commission so that they aren't simply serving the goal of deregulating.
Yeah, Abby.
So is this on? I served on the FPPC, the Fair Political Practices Commission in California. It is awesome. It's wonderful. And part of the reason it's so great is that the commissioners don't have a lot of power. We don't get to vote constantly. We don't vote on we don't really vote on advisory opinions or anything. Like, they would just put them out, and then they would come to us after a while and say, hey, we've had a bunch of advisory opinion requests about this. We think it's time for a rule. We were just voting fines up and down in adopting and debating regulations, but we weren't all wrapped up in the enforcement division would just come to us once they had already negotiated a settlement. We didn't have to have a vote, a reason to believe vote, to send them off to do the investigation and start negotiating and all that. It's a 5-member commission. There's a full-time chair, and everybody else just flies into Sacramento once a month for the meetings. But anyway, I think there are a lot of really good commissions around the country doing their best with very limited resources. If you ever want to feel good about this kind of stuff, there's this thing called the Council on Government Ethics Laws, where they all get together every December and have these meetings where they tell war stories and talk about what it's like to regulate in their states and stuff. It's really cool. So especially for the students in the room, if you're interested in this kind of work, look them up, okay? And try to get Wisconsin to pay for you to go down to Atlanta in early December. I'll be there. Okay.
Anyone else on regulation or FEC? It's okay if you don't. There was no mention in any of the comments about public financing, but we've gotten some questions about that. There is still public financing on the books for presidential candidates, though they've walked away from it over the last 20 years because they do better raising money privately. Some cities have public financing in one form or another. New York City has a matching system. Donations are matched 8-to-1. Seattle has a voucher system where every registered voter gets a certain number of dollars to commit to campaigns. Is there any promise? Help? Ray maybe is the place to start there.
Yeah, I do think public financing has some promise. I don't like some of these small donor programs that rely on national constituencies, because what you're doing there is just turbocharging. You're getting people from all the reddest or bluest places giving money across the country to a candidate running in New Hampshire or here in Wisconsin. And I think that turbocharges things. I would rather see public financing. You match donations for constituents in that district, and you make it very generous. I also want to see money go to the parties. I think parties should be funded more with public financing. My feeling is pluralism. You want to make parties and candidates less reliant on single donors, give them multiple sources of funding. Don't let all that funding be from extreme groups or small donors, some of it public financing. I mean, right now, I can't imagine public financing at the federal level, but I think it's something that is still worth thinking about.
Others on public financing.
Well, I'll just, if anyone wants to try and get a public financing bill through Congress, the charge of food stamps for politicians is going to come fast and furious. And the reality is, when there's not enough money, people feel there's not enough money to take care of basic education or streets and roads or feeding poor children. To give our beloved politicians taxpayer money is, I think, a problematic idea. The idea of having a large contributions or campaigns funded generally by a single source is, I think, actually a pretty good idea. I think candidates today, especially with the small dollar limits, have to spend a huge amount of time fundraising as opposed to like actually legislating. I think they're having to ask for money is pretty bad. I would take the idea of strong parties. Let the parties raise lots of money, get rid of the limits, get rid of the prohibitions, let the parties raise the money, stop candidates from raising money outside of their own constituencies, and allow campaigns to be funded from a large source where the candidates are not actually spending the time and having to go door to door.
But on that specific point, like, don't you think if you, if a law went through that said, okay, unlimited resources to the parties, but the candidates can't fundraise outside of their jurisdictions, that the ink wouldn't be dry on the signature before there was a facial suit against that.
There might be, but you would at least make the policy choice that you've decided that's the way to go. I'm not sure, I'm sure there'd be a suit about it, but that doesn't mean it would necessarily succeed. And I'm not sure that it would succeed because Congress probably does have the power to talk about sources. Can't raise certain types of money now. That would just be another example.
So you think, okay, so it would be just another ban on sources.
Yeah, you can raise money from your constituencies, from people who
Okay, that's not what I thought you were gonna say.
no.
Surprising bedfellows here being made. Got several questions about something else that didn't come up in the comments, and those are contributions from foreign donors, which are sometimes alleged to have worked their way into the system through dark money channels. What do we know about the prevalence of that problem, about how effective regulations are at dealing with it? Are there effective ways to, assuming we don't want that to happen, to prevent that from occurring?
I think the greater danger was actually from small dollar contributions. Report contributions of less than $200. So there were equally many charges that there were a lot of small donations from overseas. So not just big dollar donations.
So that'd be an easy fix. Just disclose everything under $200 with all the others.
Well, no, because they show up on credit cards and the names and addresses look perfectly legitimate.
But when it comes from like WinRed or ActBlue, that's a conduit contribution. So even 1 penny gets disclosed of the small donor stuff.
Yeah,
Right.
if it goes
And
there.
that's usually where it comes from, isn't it? I mean, I actually don't know. Ray might know.
No, I mean, candidates are still out there
Getting-
getting pretty hard on their own.
Okay, is this a widespread problem? How do
Sorry,
we know?
sorry,
What can we do
Ghosh.
about it?
Well, here's what I'll say. I think the issue of foreign money in our elections can never be solved when we have, as I said in my opening remarks, $1.9 billion in dark money. What dark money means is we don't know where that money came from. So it could be that it's folks who are legally allowed to give and just don't want to be seen giving, right? Special interests often do that because they understand that if they are seen giving money to a candidate or a party, their association, that's politically problematic. It could also be that a lot of that money is coming from foreign nationals. There's simply no way to know. So fundamentally, the idea that we have privately funded elections with this kind of wide open door for folks to give to 501c4 groups that don't disclose their donors but can spend money on elections, we're never going to solve the problem of foreign money, or at least feel confident that we have solved it.
Okay, we're to the point of the program where I want to mention how to get credit for the CLE work today. If you're watching online, you'll find a link to a Google form where you should enter the passcode for today, which is the word disclose, D-I-S-C-L-O-S-E, disclose. Case of that word does not matter, but it should be entered by 5 p.m. to get credit if you're online. We also got a question about funding in local races. This is something that doesn't get a lot of attention, but it has really escalated in recent years. School board races, city council, other races where a decent amount of money can sort of get the campaign out of the control of the candidate. And often state officials are not even monitoring or regulating what's happening at the local level. Are the ideas and solutions you've talked about here today also going to be useful at the local level? This seems like an area of concern for the future. What do we do there?
Well, one thing I would say is that a local race can actually be much more impacted by outside spending because the amounts in question are usually far smaller. So if you have a situation, where super PACs are spending lots of money on presidential or Senate or gubernatorial races, I mean, that's a lot of money involved there. But when you're talking about a local race, which, for whatever reason becomes a hot button race, the kind of thing that attracts some outside spending, even a small amount of money can actually have a tremendous impact there. So I would argue that yes, a lot of the problems that we've highlighted and some of the solutions that would ameliorate those would actually have downstream effects for the local races and prevent some of the special interest capture that we're seeing at the federal level.
I think one of the challenges is our politics, national politics is seeping into the local level. And groups are adopting strategies at the state level that they've used at the national level. So, Sarah was saying you could just dump a ton of money into a race that makes a larger point or throws fear into people who might disagree with you. I think unions are doing this in my state, Massachusetts. They do this quite a bit, depending on what are the issues before the state. But I don't know a way around it because we have so much information now through social media, easy ways to collect money over across the country. I don't know how we fix that at the local level.
I haven't heard a lot of support here for the direction the Supreme Court has taken campaign finance the last 20 years or 50 years. Is there some remedy you would suggest? Is there a constitutional amendment? Is there a statute that Congress could adopt, let's just assume they're willing, that you think would be helpful?
Well, talking about constitutional amendments in any context, you start to sound like one of those tinfoil hat people, but sure, I mean, that would be great if we could get that done. What I tend to focus on in my work is, campaign finance has gotten so deregulated over the past, well, we'll call it 50 years too. It has been steadily chipped away, and there's so much now that is permitted that I think a lot of people can feel somewhat hopeless about it and say, well, if you don't overturn Citizens United, then there's nothing we can do. I actually push back against that sentiment because the basic problem is that even the bar that Citizens United set, which was that all of this outside spending is disclosed and is independent, we're not meeting that bar. We're well below that. So I think if Congress was serious and if voters emphasize to Congress that they should be serious, there are bills they could pass, the Disclose Act, the Freedom to Vote Act, that would in fact get us to at least some baseline without going as far as a constitutional amendment.
Yeah, and I'll just add that I think it was your opening statements, Barry, but about the IRS not acting, right? There's an appropriations rider that's been in effect since 2014, 2015, maybe, that says the IRS cannot regulate political spending by corporations and cannot require disclosure. And that appropriations rider has stayed consistently no matter which party's in charge. Okay. So one thing would be to get rid of that and let the IRS do something if it had the kind of political will to do it.
I have a question for the attorneys. How hard would it be to regulate any type of spending in an election from these 501c3 social welfare organizations? Is it possible to say, if you spend money in this election, you have to reveal who your donors are?
That's essentially what the Disclose Act does.
Okay.
Yes, if you spend more than $10,000 on an election, you have to disclose the donors. But there's all, I mean, without boring everyone with all the details, there's opt-outs, right? So, one of the pushbacks that the law sometimes gets is, well, that's forcing people who donate to that group to be revealed, and they don't want to be. There's an opt-out. If you don't want to support their election spending, you can earmark the money for non-election spending, and then you wouldn't be disclosed. So yeah, I think that would be a tremendous step. It would combat foreign money. It would combat just generally the problem of lack of transparency. I think it would go a long way to restoring people's trust in government, which, as you pointed out, Abby, is something we need.
Ray in particular mentioned funding of parties as opposed to funding of candidates or groups. Assuming that happens in some place or it's appealing for some of you, how do we decide which parties warrant funding? What about minor parties who are sometimes qualified parties in states to be on the ballot automatically? Or if Ray, you've thought about this.
Well, no, I would just say, if you want minor parties, take all the limits off, because that's the easiest way for a minor party to raise money. You'll get a patron to say, yeah, I want the Green Party to do better. And it would make it a lot easier for them than having to work under these highly restrictive rules.
Yeah, I don't think you have to limit it to just the two major parties and who could raise the money.
I mean, I'm thinking about the public financing system that was used at the presidential level for all those years. It had different standards for major parties who would get the funding automatically in the primaries as potential nominees and in the general election. But the third parties always had to first prove their performance in the general and earn, I think it was 5% of the vote, and then could be paid afterwards. So it was this sort of gamble for those parties. So that's unequal treatment, but maybe aside from that's no longer relevant either.
If you're coming at it that way, it's another example of why the basic statute is flawed.
Yes, right. That's there from the beginning. Okay, we've just about come to the end of this session. It's wonderful that you all could be with us in person and online. Please hang around if you're here in person to ask questions, and please join us again for future events. Thanks again to all of our panelists. Let's give them a round of applause. And thanks again to the Elections Research Center, State Democracy Research Initiative, and Stafford Rosenbaum. Have a good day.